As of March 12, 2024, New York employers are effectively prohibited from accessing personal social media accounts belonging to employees and job applicants. Under this new legislation, it is unlawful for an employer to request, require, or coerce any employee or applicant to disclose his or her username, password, or other authentication information used for creating, sharing, viewing, or otherwise accessing electronic personal accounts. This applies to all accounts and profiles on electronic mediums, including blogs, podcasts, sites used for uploading or downloading videos or photographs, and sites used for sending or receiving instant messages. Employers cannot lawfully require employees or applicants to access their accounts in the employer's presence, nor can they require an employee or applicant to reproduce any of the content contained on their personal accounts or profiles. Employers are also expressly prohibited from retaliating against employees and applicants who refuse to comply with unlawful instructions from the employer to provide information or access prohibited under the law. These restrictions do not apply to accounts that are not personal to employees or applicants, such as company-owned social media profiles or login information used for an employee to access the employer's internal computer or information system. Importantly, this law does not prohibit employers from viewing, accessing, or utilizing information about an employee or applicant that can be obtained without any required access information, that is available in the public domain, or that is voluntarily provided to the employer in connection with an investigation into potential misconduct. But given the broad language of the new law, it may be difficult to show that access is granted voluntarily by employees, even where the information is provided to employers with the consent of an employee. With this new law, New York joins more than 20 states with similar protections, including California, Connecticut, Delaware, and New Jersey. These state laws are in addition to the Stored Communications Act, which criminalizes certain access into electronic facilities, and the National Labor Relations Act, which prohibits employer actions that have the potential to chill protected concerted activity, even when it takes place online. Accordingly, employers should evaluate their current policies and practices to ensure compliance. Employers should also consider the practical impact of this new law and how they conduct many workplace matters. For example, employers that conduct social media checks during their hiring practices should not request access information from an applicant, but rather limit their review to publicly available accounts. Similarly, employers should make sure not to capture and store login information and passwords when properly monitoring employee personal use on company-owned devices, or consider banning use of such accounts on company-owned property altogether. Employee personal accounts may also be an issue in workplace investigations, especially if a complaint includes an allegation that a coworker engaged in misconduct using their personal account. However, even in those situations, employers can only access such personal accounts if information is provided voluntarily, and it may be difficult to later show that when hiring, discipline, or termination is at risk, an employer applicant felt they had a choice in handing over this information. Given the complexities created by the new law, employers should take steps to confirm the separation between company-owned social media accounts and employees with permission to use those accounts. Legal counsel with knowledge in this area should be consulted to make sure employer practices and policies are not running afoul of this new law. As always, if you have any questions about this new law or any other labor or employment matter, please contact a member of our team.